Welcome everyone, and thank you for joining us today. I'm Cody Nunn, and I'm joined by my colleague, Chen. Our presentation today will be how to prepare for the H-1B Lottery and electronic registration system. For those of you who are not familiar with our firm, Brian Swanson is a full-service, 40-plus attorney law firm based here in the Northwest. Our immigration team has been helping both individuals and businesses successfully navigate global mobility challenges for more than 65 years. We assist clients with all types of non-immigrant employment visas, including H-1Bs, which we'll discuss today. Before we begin, I want to remind you that all lines are muted. Please use the chat box to submit your questions throughout the webinar. We'll answer questions as time allows at the conclusion of the webinar. If we were unable to answer your questions today, we'll be happy to follow up with you after the program. Presentation slides are posted on our website as well. Please go to ryanswansonlaw.com/events to download. Our presentation today will be around 30 minutes. A recording of this webinar will be posted to the website soon if you would like to share it with colleagues. Thank you again for joining us today. Now we'll jump right in.
Thank you everyone for joining us. As Cody mentioned earlier, the presentation today will be 30 minutes. We'll go over what is the H-1B visa briefly, then we'll discuss the H-1B visa and the electronic registration process. And then we'll talk about what to do if you're selected and options to consider if your applicant is not selected. So moving right into it. An H-1B visa is a temporary work visa for individuals working in specialty occupation. There are two types of H-1B visas, cap exempt and cap subject visas. For the purposes of this presentation, we'll be focusing on cap subject visas or visas subject to the lottery. As mentioned, the position has to be a specialty occupation, and it normally requires at least a bachelor's degree in a specific specialty field or equivalent work experience. Based on our practical experience, if the applicant is relying solely on equivalent work experience to say that they have at least a bachelor's degree, this is often a more challenging H-1B to pursue. And as most of you know, a H-1B visa provides work authorization for a maximum period of 6 years, unless the individual has a Form I-140 approved. The H-1B lottery is held every year. There's an annual quota or cap of 65,000 H-1B visas for individuals with a bachelor's degree or higher. And then there's a 20,000 quota for H-1B visas for individuals with a US master's degree. H-1B visas are available starting from October 1st, 2022, even though the registration period starts in March. So if you have an applicant who's selected in late March, then you would know that they can officially start an H-1B status on October 1st. USCIS uses a lottery system to allocate H-1B visas, and fewer than 50% of petitions were selected in recent years.
Before the registration requirement was implemented in 2020, employers, with assistance from Immigration Counsel, submitted complete H-1B petitions, including all the filing fee checks, to USCIS on April 1st to be considered in the lottery. Now, with the implementation of the H-1B registration process, employers are no longer required to submit complete H-1B petitions to be considered for the lottery. To participate in the H-1B lottery now, employers must submit an electronic registration for each H-1B candidate they wish to enter into the lottery. The registration must contain the employer's information, as well as some information about the candidate, including their name, date of birth, country of birth, citizenship, and whether they are eligible for the US Masters cap. There is a $10 registration fee per candidate. Therefore, employers are no longer required to submit all the filing fees upfront to be considered for the lottery. Once the employer is notified that the candidate's H-1B registration was selected, the employer will then need to prepare and submit the complete H-1B petition with all the filing fees to USCIS. Jen will discuss what happens once an H-1B registration is selected later in the presentation. As a general overview of the registration process, This year, the registration period, which is when employers are permitted to submit registrations, will begin on March 1st and will end at noon Eastern Time on March 18th. This will be 9 a.m. for those of us in the Pacific Northwest. To submit the registrations, employers will be required to pay the $10 fee. USCIS will then notify employers of the selected petitions by March 31st, 2022. And employers will have a 90-day window to file H-1B petitions, generally from April 1st to June 30th for the first selection. If there are additional lottery selections, employers will be provided a 90-day window to file the H-1B petitions once they are notified of the selection. To start the registration process, employers will need a MyUScis account. Employers who are new to this process will need to set up a new MyUScis account. This can be done starting Monday, February 21st. We recommend that employers designate an authorized signatory for the H-1B registration process and have that person create an account and log in well in advance of March 1st so that they can become familiar with the website prior to the start of the registration period. We also recommend that the authorized signatory keep their login information in a safe place to protect against having their account locked out. Then, once the registration period begins, the attorney will be able to prepare the H-1B registrations for each candidate in their MyUScis account. The employer will review and approve the H-1B registration. If changes need to be made, this can be done while the registration period is open. An electronic handshake is required for the attorney to provide the registration information to the employer to review and approve. First, the attorney will prepare the H-1B registrations and sign and submit the Form G-28, which is an attorney representation form, in the attorney's MyUScis account. Then, MyUScis will generate a passcode for the attorney to provide to the employer. The employer will need to enter that same passcode when they log into their account and add the attorney as a representative in order to start reviewing registrations. The employer may then review the registrations and approve or reject them at this time. Once the employer approves the registrations, the $10 fee may be paid and the registration will be submitted with USCIS through the MyUScis account. We highly recommend that the authorized signatory be ready and available from March 1st to March 18th to be able to review and approve H-1B registrations.
So once the registration period has ended, USCIS will conduct an initial selection process. USCIS intends to notify employers no later than March 31st, 2022. And based on our experience from the last 2 years, USCIS sometimes might even notify employers a few days earlier than this intended date. Employers can sign up to receive an email or text notification that the MyUScis account has been updated. Any unselected registrations may be held for a period of time in case they need to conduct further selection. For example, in last year's H-1B lottery, there was a total of 3 selections, and that was very exciting for people who are selected in the later selections. One question we get as attorneys is how can employers maximize H-1B approvability before registration? Prior to 2020, employers would prepare and file a complete H-1B petition, submit it with USCIS, and then USCIS would conduct the lottery. Now, with this pre-registration, employers are saved from going through the hassle of having to prepare a complete petition. But of course, it's very important then to ensure that every registration qualifies as an H-1B position. This is why we recommend an all-inclusive approach by identifying issues upfront prior to this registration. We would review documents such as whether or not the position is actually a specialty occupation, whether or not the beneficiary's degree is in a specialty field, their degree completed date, and all of these nuances to minimize the rate of denial or pushback from the government. There is the requirement that the employer must file a non-frivolous petition. This means that if the employee obviously does not qualify for H-1B position, the employer should not try to submit them in the H-1B registration, because if they are selected, it would be a frivolous filing. And USCIS reserves the right to investigate employers who do not file an H-1B petition for selected registration. Based on our understanding, this is only when a pattern has been identified and occurs. So if you have an employee who is registered and selected, but unfortunately you're not able to move forward with filing an H-1B petition on their behalf, we would recommend keeping documents of the reason for non-filing in case USCIS makes an inquiry in the future. So what to do if you are actually selected for the H-1B? There are many steps involved. First is registering with the Department of Labor if you're a first-time H-1B petitioner. This can be done prior to the selection process, and you can do this concurrently while you're registering if you're a first-time H-1B petitioner. The time to take to register with the Department of Labor should be approximately 1 week, and they usually just need documents to verify your FEIN. Then, once you're selected, or prior to selection, you can submit a labor condition application with the Department of Labor. This signals to the Department of Labor that you intend to file a H-1B position, and you're asking the Department of Labor to issue a wage for the position, or to ensure that the offered wage meets the prevailing wage of the region and the position. Labor condition applications usually take about a week for certification. Once the labor condition application is submitted, employers must maintain a public access file, and they must maintain the public access file for a certain amount of time. So it's very important to ensure that you're keeping your documents available and ready. And then, of course, you would prepare and file the H-1B petition within the USCIS deadline. It's very important to file the H-1B petition within the 90 days because USCIS will often not overlook late filing. So in terms of H-1B fees and filing requirements, all H-1B fees and costs must be paid by the employer. They cannot be paid by the employee. This is only required if the H-1B petition is selected in the lottery. The filing fees for Form I-129 or for the actual H-1B is $460. There is also a $500 anti-fraud fee and a $1,500 or $750 ACUA training fee, depending on the number of employees you hire. There's also an optional $2,500 premium processing fee in case you would like to hear of a decision or response from the government within 15 calendar days. So what other documents would we advise to include in the H-1B filing? Usually we advise to include a broad range of documents, from company documents, documents of the petitioner, as well as information on the specific specialty occupation. Specifically, in terms of company documents, we would suggest current audited financials or a US income tax return showing that the petitioner has enough income to pay for the H-1B employee salary, annual reports if you're a public company, and information on the company such as website printouts, marketing brochures, or any other information you have. We always encourage petitioners to register on USCIS's business verification platform, and that is through Dun & Bradstreet. You should be able to do so without paying an extra fee. And then as to the job information, you would want to include job information that confirms the position is indeed a specialty occupation. This would include detailed job description, as well as information on how the position requires a specialty degree at least a bachelor's degree or higher level. We have received higher scrutiny for certain positions, including analysts, graphic designers, sales and marketing folks. And it's very important to show that the bachelor's degree is in a specialty field. So for example, if you have a marketing team and everyone on your marketing team has at least a bachelor's degree or higher in marketing, this is very good evidence to show that the position requires a bachelor's degree in a specific specialty field. And of course, you would want to include documents that the foreign national maintained their status, if you're filing for a change of status, as well as their education docs or any education equivalencies you might obtain. So as a reminder, we would be happy to answer any questions at the end. Please submit your questions and we will get to those at the conclusion of the webinar.
Unfortunately, some of your registrations may not be selected in this year's lottery. Depending on the H-1B candidate's current status and or their country of nationality, they may have other options. If your candidate is a student, they may be currently working for you because they have an optional practical training work permit, also known as an employment authorization document or EAD. OPT EADs are valid for 1 year, and students may work for any employer as long as the work is related to their degree program. If the student graduated from a STEM degree program, they may be eligible for a STEM extension, which allows the student to extend their work authorization for an additional 2 years after the expiration of their OPT work permit. It is important to note that in order to employ someone with a STEM EAD card, the employer must be enrolled in E-Verify. If you have a student employee, we recommend that you enter them into the H-1B lottery every year so they have as many chances to be selected in the lottery. If your employee or potential employee is a Canadian or Mexican citizen, they may be eligible for a TN visa if they'll be entering the US to perform work in one of the listed professions in the United States-Mexico-Canada agreement. The TN visa category allows qualifying individuals to work in the US in 3-year increments, renewable indefinitely. The E3 visa category is available for Australian citizens, and the E3 requirements are similar to the H-1B requirements, meaning that they must be performing work in a specialty occupation that requires the theoretical and practical application of specialized knowledge gained from a bachelor's degree in a specific specialty field. E3 status holders are permitted to work and stay in the US for 2 years at a time, and their status may be extended indefinitely. The H-1B visa category is available for citizens of Chile and Singapore. The H-1B requirements are also similar to the H-1B and E3 requirements. H-1B status holders are permitted to work and stay in the US for 1-year increments, and their status may be extended indefinitely. If your company has other locations in the world, the employee may be able to work in the US in the future in L1 status, even if their registration was not selected in this year's H-1B lottery. To qualify for L1 status in the future, the employee must work for the employer at one of their affiliated entities abroad for at least 1 year in a managerial position or position that requires specialized knowledge. If they'll be returning to the US to perform a managerial role 1 year later, they will be eligible for L1A status, which will allow them to stay and work in the US for 7 years. If they will be returning to the US to perform a role that requires specialized knowledge, they will qualify for L1B. L1B status holders may stay and work in the US for 5 years. Another visa category called the O1 visa category is available for individuals with extraordinary ability. In order to qualify for this category, the individual must meet certain criteria such as receiving prestigious awards or publishing articles. Individuals who are not selected in the lottery and who do not have many other options may return to school. Please note that they may not be eligible to return to work until they have been enrolled in school for a specific period of time as required by the school. Lastly, some individuals may be eligible to apply for a work permit with USCIS if they're married to an H-1B status holder who has an approved Form I-140 petition. Spouses of L1 and E visa holders are also eligible to apply for a work permit with USCIS. Further, USCIS just recently announced that spouses of L1 and E visa holders are work authorized incident to their status. This means that spouses of L1 and E visa holders are automatically permitted to work for any employer in the US. At this time, the Department of Homeland Security is working on updating the instructions on the Form I-9 and the Form I-94 record. for spouses of L1 and E visa holders so that they will be permitted to work in the US without applying for a separate work permit with USCIS. Please be sure to connect with an immigration attorney to explore these different options. That's all that we have time for today. Thank you so much for listening.
Thank you so much for joining us today, and we will now welcome questions.